SJC-12469, Commonwealth v. Rafael Fontanez.
Good morning.
Good morning. Good morning.
Mr. Shepherd-Brick, good morning.
Good morning. May it please the Court. David Shepherd-Brick on behalf of the Commonwealth. The motion judge erred in allowing the defendant's motion in limine, excluding the testimony, by creating a right not to be subjected to a suggestive in-court identification procedure. There's no such right.
Well, he has a right. He has a right to that screen, doesn't he? He has a right to protect the identification.
He has he has attacked. I mean, he has a right if he wants to waive his confrontation right.
Right. He's. I mean, I guess he's exercising he's exercising a right to preserve his ability from being wrongfully identified, right? To me, I look at these as separate inquiries. I'm not sure he's got to make a choice here. That doesn't mean he's not waived his right to confrontation, but he has a right here, right, to put that screen up to protect his ability not to be wrongfully identified at trial, right?
Well, I think that, but the right against having a bad identification made at trial is a due process right. So the right isn't violated until the identification is admitted at trial. And you can't have an identification at trial if you don't have either an untainted pretrial identification or a good reason. So in this case, the defendant moved to suppress this witness's identification. If he's successful, there will be no out-of-court or in-court ID made at trial. If he loses, which he did in this case.
I'm just suggesting you're arguing more than you need to argue. I mean, if this identification is not allowed, basically this person walks free, right? This is the primary identification of this guy. So I understand you meet the first step of 211.3, which is this is all or nothing for the Commonwealth.
Right.
The second step becomes more complicated, right? The motion to suppress is denied in a totally appropriate process. Mm-hmm. Then we get to the second stage, which is, has his right to confrontation been, it's the second right? He's not going to be able to confront this witness. The witness is dead.
Correct.
So the question is, are the prerequisites to being able to use this identification satisfied? There's full cross-examination, and he chose not to be in the room during the first part. But I take it you don't need to say he doesn't have a right? You can still win this by...
No, absolutely. I mean, defendants can be forced to choose between constitutional rights. Right. Article 12 assumes that a defendant either exercises his right to testify or exercises his right to remain silent. Right. So I agree that that's not an all or nothing proposition. Right. And the due process, the right to confront his accuser face to face. He was actually in the courtroom. Right. He was behind the judge's bench when he testified. But the right of confrontation is the opportunity for face-to-face confrontation, not the exercise of that right.
And to a certain extent, what we're focused on, or should be focused on, I would assume, is the ruling on the motion in limine and whether that ruling was proper. Correct. And that is where we are using what standard, would you say?
So it's an evidentiary ruling, so it would be abuse of discretion. But here, the argument is that the judge committed a significant error of law because he applied a factor, a requirement that has never been applied before. So it was both a significant error of law and an abuse of discretion.
But it is a pretty interesting issue. I want to get I want to go back to Justice Kafka's point in a minute, but along those lines, what your main argument is that we keep on saying, case after case, that when we're dealing with whether or not there's testimonial hearsay, we look to the Sixth Amendment, because cognate provisions of the Declaration of Rights do not provide enhanced protection.
Right.
And clearly, under the Sixth Amendment, the fact that he was behind a screen doesn't raise the Confrontation Clause issue.
Correct.
And that is the simplest, most basic argument you have, right?
Yes. And I think that is the sort of, that's where the case begins and ends. I mean, you can certainly get into the Article 12 question about his opportunity for cross-examination, but that's the fundamental error by the motion judge, is that he applied an Article 12 trial right to the question of whether something was admissible under the Sixth Amendment. So that's really where things went awry.
He sort of imports Emerald into testimonial hearsay,
Right.
where there is a choice to be made under Emerald, and the Emerald could have been waived anyway.
Right.
So what do you say is the scope of the Article 12 right?
The scope of the Article 12 right is certainly the opportunity for face-to-face at trial. The court has never said that there is a requirement for face-to-face any other time other than a trial. There's certainly a suggestion in some of the prior cases that the idea that the prior testimony met all of the particulars of the trial right lend itself to admission under Article 12, but there's never been any requirement that it meet all the requirements. I mean, the historical right is the right of cross-examination, going back to, King versus Payne, and the right for the defendant simply to challenge the testimony given in cross-examination.
But we have allowed testimony at trial where the declarant is not at trial, so there's no
Right.
face-to-face. Dying declaration, excited utterance. There's no face-to-face there.
Right, because those were acknowledged exceptions at the time of the passing of the Declaration of Rights, as was the admission of prior sworn testimony.
So are you saying that we're going to be limiting the availability of hearsay only to the hearsay which was accepted in 1780? U.S. Supreme Court has spoken of that with regard to its interpretation, but
only as to testimonial hearsay, and I think as the Sixth Amendment limits it.
And that's because of the Confrontation Clause cases that came out and changed how we understood it, correct?
But the U.S. Supreme Court does not require face-to-face confrontation. It's our Constitution which says that.
Right. And our Constitution has never provided, under this particular right, more protection than the Sixth Amendment. So
It has a trial.
a trial, but not in terms of the admission of prior sworn testimony.
Right.
But isn't this, Emerald was different. Emerald involves the defendant wants to look at the witnesses. Here, the defendant wants to shield himself from the testifying police officer. I just don't, is this much easier? It just seems to me that he can't be, the witness is dead. The question is, are we going to use, has the requirements for allowing a dead witness, testimony been, and they seem to be met here, don't they? I mean, it's just.
They are.
There's full cross-examination. The defendant could have been in the courtroom. He was in the courtroom. He just is hidden from the police officer. I just don't understand what Judge McDonough is doing exactly.
I think that was our issue with it too, is it just doesn't make sense. He had the full opportunity for confrontation at the prior hearing. He made a strategic choice with the advice of counsel. He filed an affidavit saying, I know I have a right to be there. It's because it's an important stage in the proceeding. I'm choosing to waive that right, I do so knowingly, intelligently, and voluntarily. So,
Well, let's put the best argument we can on for the defendant, though, here. And the best argument for the defendant would be that before you can get to the Sixth Amendment, you have to address Article 12 and the right to face-to-face confrontation. And here, the confrontation has to be as to the prior cross-examination, because the reason that it's not testimonial hearsay is because there's somebody who's unavailable as a matter of law, and there was a prior opportunity for cross-examination. So if you want to take the best argument for the defendant, the best argument for the defendant is that you have an Article 12 violation as it relates to the former testimony. I mean, that's what the argument has to be.
I think it is. I think that argument doesn't succeed because it's not, Article 12 has never prohibited the introduction of prior sworn testimony simply because the prior confrontation was not face-to-face. But even if Article 12 requires a prior opportunity for face-to-face, that was satisfied here.
Because if you can't waive it, then he had to be behind, he couldn't be behind the screen.
Correct.
He would have had to be at the table.
Right, and that's what the court said in Emerald. If they accepted the argument made by the dissent in that case, you couldn't waive your confrontation right. And your confrontation right, just like your right to testify, is not always to the defendant's advantage.
Can I ask you to help me with a couple things? First of all, I thought that it was only allowed in part, and that there were other witnesses who could testify.
There were other witnesses who could testify that they observed the defendant in the bar that evening. This is the only eyewitness who puts the defendant as the attacker. There was another witness who saw him who died before the hearing, and there was another witness who put him closer. That identification was suppressed.
So is that the only testimony that you have that would, or only evidence that you have about the defendant's guilt?
Yes, that is. I mean, we have circumstantial evidence, but that he was in the bar. But in terms of putting the knife in his hand, that's our only testimony.
Okay. So let me just continue with that. The other question I have is, this is a 211-3 appeal, right?
Mm-hmm.
You're saying Justice Gaziano made a mistake,
Yes,
and one that we should correct because it was an evidentiary mistake that he chose not to correct,
correct.
and that was somehow an abuse of discretion. So we're only reviewing the 211-3. We're not reviewing the lower court. We're reviewing only what Justice Gaziano did.
Well, yes, although to review whether or not he made the correct ruling, you have to get to whether the trial judge made the correct ruling.
So you're saying in every case of judges making a mistake with the evidence below that we have to correct it on 211-3?
Absolutely not. I think that this case presents an extraordinary circumstance. One, it's our only identification witness. Two, there's a significant error of law in the application of the defendant's confrontation clause right. I'm not sure what qualifies as
So is it comparable to the Rule 15 jurisprudence, meaning we've got an improper allowance of a motion to suppress, which is essentially what this is?
Right, and the difficulty is that there are some cases out there from this court that say that you can't appeal a motion in limine under Rule 15, though I understand there are other cases that have proceeded that way.
Can we go back to Justice Link's point, though, because I have the same concern as to the exceptional circumstances. As a single justice, are you saying that every time there's maybe not every time there's an evidentiary error, but every time that the Commonwealth's case is now going to have to be circumstantial because it wouldn't be otherwise, and that if you really dig down deep, there might have been an error, because this is not the easiest issue, that means that the 211-3 needs to go forward because it's a remedial error in exceptional circumstances, I guess?
No.
I mean, I am concerned about exactly the point that Justice Link was making.
What I would say is that that's not enough, just that that there's an error. But it's a significant error. It's a misapplication of the standard, which is what this court held in DM, that the trial judge applied the wrong standard.
And in fact, aren't there, I wouldn't say numerous cases, but enough examples of Commonwealth petitions under 211.3 that are similar to, in nature to this, that have the same effect on the Commonwealth, that are allowed by a single justice, that are not challenged, so we don't see those?
And I think that's correct, because if you're dealing with whether the motion judge properly weighed a certain factor, if he had found that the prior opportunity, the prior cross-examination was not, the issue wasn't sufficiently similar, or he had found that the defendant had a different motive, that would not be sufficient. It's because he applied a legal precedent for which there is none.
Well, but the first step is the most important, right? That if this isn't changed, the case has to be dropped, essentially.
Yes, that's correct.
So it's extraordinary in the sense that we've got a brutal assault. This is the only identification evidence, and there appears to be a clear, well, there may be an error of law by the motion judge. So that's how you, it's not we're correcting every evidentiary issue. We're dealing with the extraordinary situation, which is this crime is not going to be able to be prosecuted because this is the critical evidence in the case, right?
Right.
So why do we get to the significant error of law unless and until we find that it's extraordinary for other reasons?
I mean, I think to find it extraordinary, I mean, that's what the court has said in terms of extraordinary circumstance, that it has to be that type of irremediable error, and then it also has to present the kind of significant error of law that requires.
And a significant issue of law or
Significant
an error
issue
of
of
law?
law.
Okay, because the problem is that, well, let me ask you this. Let's assume there were 4 eyewitnesses, all of whom saw the stabbing. Only one was suppressed on these grounds. Would that be an extraordinary, would that justify 211.3 relief?
It would certainly be more difficult, especially, again, if there are other witnesses, so it doesn't really present that type of extraordinary circumstance. It's still I think you would meet the significant issue of law, but I don't know that you would meet the extraordinary.
The problem is that it's one thing to say it's a significant issue of law, because that you can see when you read it. But to decide whether it's a significant error of law, you effectively have to decide it. And the consequence of, if we're supposed to determine whether it's a significant error of law and deciding whether or not we're going to hear it, we essentially then have to decide every case that comes before us to decide whether it's extraordinary or not.
Right,
Well,
Is that what you're asking us to do?
right.
no, I don't think you have to do a full, the single justice obviously doesn't have to do a full analysis, but it has to look at what the judge below did. And if the judge below applied all the factors and it's within his discretion, that's the end of the consideration. But if the motion judge applied the wrong factors or applied the wrong law or made up an additional requirement, then I think that's when you look under the hood and say, okay, what is really going on here?
We've already looked, you're basically saying you look under the hood
You take, I guess you
initially, and
take
then
a peek
you...
and then put it up on the blocks if you have
All
to.
right, but it may come down to this issue of significant issue of law versus significant error of law, maybe where we differ. Okay, thank you.
Thank you.
Mr. Frothingham, good morning.
Good morning, Chief Justice Gantz. Good morning, Your Honors. My name is Tom Frothingham. I represent Rafael Fontanez in this case. And it seems to me that we sort of jumped into the substance of the matter, and that really this is, I mean, whether or not the Commonwealth can proceed after the evidence is suppressed does not make this an extraordinary case. Evidence is suppressed all the time and cases can't proceed. And I would first argue that this,
Although
That's
that's
not-
true, counsel, but that usually, that's through a motion to suppress, which then brings in Rule 15, which then gives the Commonwealth a bit of a better avenue for appeal than a 211-3. So this is a unique kind of situation.
well, they can appeal it, they can, yeah, I don't think that, it may be the only avenue of appeal, but the fact that a case has to be dropped because of a suppression motion or a motion to exclude evidence is allowed does not present an extraordinary circumstance.
Well, but Rule 15, this normally comes up in Rule 15. When what happens is a motion to suppress is allowed, the Commonwealth seeks review, and if it's the only evidence present and we think there may be an error, we usually allow an interlocutory appeal of that, usually in the appeals court. So that's standard. And if it's the only evidence, it usually meets the requirements. But I don't know where that gets you.
Well, okay, if you consider this to be an extraordinary circumstance, then you get to the next question of whether or not Justice Gaziano abused his discretion in denying this. And then that requires, you can peek under the hood. It doesn't require a full analysis, but you have to make a summary evaluation of the facts. And the facts in this case show that there was a hearing in which there was no burden on the Commonwealth to prove anything, and the judge, the burden was on the defense to prove that the identification was somehow tainted. The judge found the Commonwealth did not.
But the burden, I find your argument about the burden of proof confusing, because obviously the burden of proof at trial is going to be beyond a reasonable doubt. What the burden, the real question is, was there an opportunity for cross-examination and an opportunity, I'm not even sure there needs to be an opportunity to confront the witness, but it's the burden of proof will shift at trial. So I'm just not sure what that matters. We're not deciding whether this is truthful or not, are we?
Well, I gave a couple of examples, but if you go back to the Maddox case, Maddox was the
It's
case.
like the 154 US, we're going back into time?
Yes, this is back in 1896 or something, but this is cited favorably in Crawford when the court refers back to this sort of they refer back to Maddox to indicate sort of this period in which the confrontation clause, they view it as being correctly applied. Then there was this drift up to Roberts and this sort of indicia of reliability, which they disapproved of. In Maddox, the court comments that the reason the evidence is admissible in the second trial is because there was a conviction in the first. And it was important that if you're going to offer evidence subsequently from a prior hearing, you would hope that there is some conclusion that the Commonwealth has borne a burden of proof.
So let's stop on, so how many cases, if you did a all feds and all states search, would you find, because we're interpreting the Sixth Amendment here. We're not interpreting Article 12. This is what's testimonial hearsay. How many times would there have been Commonwealth or the United States or the people bring a case, there's a mistrial because of a hung jury, so the burden of proof wasn't met, and then something happens and the former testimony comes in at that prior trial where the burden of proof wasn't met? I mean, how many cases do you think we'd find?
I don't know, Your Honor.
Lot, though, right?
I don't know. I didn't search that. I was looking for.
But that's the answer, isn't it? I mean, it would be,
Where
do you
you're
think there's any
introducing-
chance under the Sixth Amendment that if there's a hung jury, that the key witness dies, and what the court's going to say is, you can't have that former testimony that was fully cross-examined at trial because the Commonwealth didn't meet or the United States didn't meet their burden of proof. Do you think there's any chance there'd be such a holding?
Well, so let's assume half the jury didn't believe that testimony. And then now you're going to introduce it to a second jury with no ability to evaluate the same witnesses who half the first jury didn't believe.
I know, but
I think that's a serious problem.
So you think there's actually a chance that a court would say that can't be admitted, thoroughly cross-examined, and there's a mistrial?
I did suggest in my brief that it's necessary to go beyond the Sixth Amendment, that that's under Article 12 face-to-face.
I know, that's a different
clause.
argument.
Well, I
I'm
know,
happy
but I
to
was saying that you
transition
could
to that.
extend it. I mean, you could, if in this kind of case, because what are you going to do if you have a case, like I pointed out, in the cases where a case is retried in a different jurisdiction? What if you have an acquittal? If you're saying you can have tried in state court and failed, got an acquittal, there's no reason under your analysis that you wouldn't be able to allow that test to come in federal.
There's a
What-
huge reason.
What's that?
The huge reason is that when it's a criminal case, absent the most narrow of circumstances, in a criminal case, other than a civil case where you have to be predecessor in interest or privity, in a criminal case, it has to be the same prosecution, the same proceeding. So it just doesn't work. That's why.
I'm not sure I understand that. If you have a.
It has to be the same prosecution. You can't take former testimony in a criminal case from Kansas involving a different prosecution and then bring it as former testimony in South Dakota. That's not what the former testimony exception is in the criminal side.
Well, it seems that if you go back to Maddox again, those were in two different jurisdictions. The reason they tried the case in the wrong jurisdiction in the first instance, and it was to be retried with the prior testimony from the first trial. But that required that there was a conviction and not that. And in these other cases, all the cases cited in the Commonwealth's brief regarding prior testimony, there is a judgment about the value of that prior testimony that shows that someone at least believed the testimony. I mean, you could have, for instance, if you had in the Hurley case, if you're just going strictly on the 5 criteria, if you have a pretrial detention hearing that the judge finds there was insufficient evidence in the pretrial detention hearing, you still have all the criteria 1 through 5. You've got prior recorded testimony under oath on an issue, and you've had the opportunity for cross-examination. And then the judge says, "Oh, there's not enough evidence to hold the defendant." Then the victim dies. You could try the case based on the Commonwealth's argument. You could try the case based on the testimony given in the pretrial detention hearing. And I don't know why that would not be permissible unless you consider the context of the previous testimony and the outcome of the hearing.
Now, if we can go to the reasoning of the judge here, which you did not seem to be focused on in your brief. Are you conceding that we should not adopt the reasoning of the judge below, or is there a way that we can?
Well, I think that the judge below, I think may have missed, I don't know, I think the issue, for instance, if you're comparing the issue of whether or not the hearing on the identification and whether the identification was untainted, and simply looking at whether the defendant was, or the witness was not influenced by the police procedure, that's different from having the witness identify the defendant at trial.
But the judge below's main reason was that he was forced to choose between his right to confront and his right. That's his reason.
Well,
But he really didn't. He waived that by.
Well, Your Honor,
He exercised his right to protect the identification, but he's not been deprived of his right to confront witnesses, has he?
Well, the witness died, he can't confront
Oh,
him. This whole idea that it's waived.
That part, regardless of whether this is admissible, he's not going to be able to confront the dead witness, right?
Right, but the idea that he waived his trial right to confront the witness because he concealed his identity at a pretrial
No,
hearing.
he didn't. He had a full right to cross-examine him. He was present in the courtroom, but behind a screen to preserve another right. Doesn't mean he wasn't given an opportunity to confront the witnesses against him, does it? I mean,
Well,
any
I
case
don't-
besides this one that ever said that?
There was cross-examination, but
full cross-examination.
Right, but there was no, I mean, you're cross-examining, but I still have to go back to this, that at this hearing, you need to have somebody place a value on the answers given in this cross-examination, and that hasn't been done.
There's never been, every case that deals with former testimony says prior similar motive and opportunity. You don't have to, if you don't ask one question, the former testimony applies. So as to that last point, there's no case that's ever said that.
Well, I think those are all in cases where there's a burden on the state as well. And if you look at these cases, I mean, look at the cases that are cited by the Commonwealth. They're all, there's these decisions are all based on a hearing in which the burden is on the Commonwealth. The Commonwealth has met the burden of proof against the defendant. To say, and the concept of having the opportunity for cross-examination always comes up when there's a direct accusation against the defendant and a denial by the defendant. In this case, in this pretrial hearing, there was none of that. So you're admitting.
I'm confused by that. He has the same incentive to undermine the credibility of the victim, right? Absolutely. He's making all the right points, that the victim's heavily medicated, he's in tremendous pain. I mean, I'm confused what he was.
Well, he's making the point that the police procedure was tainted the identification, and the witness is saying, and the witness is claiming that his memory was clear, that he's the 6 to 8 drinks he had prior to it didn't affect him, that he wasn't on drugs at the hospital when, all this testimony, and there's nobody to judge that testimony. The judge decides, well, there's not enough to convince me that this shows there is an irremediably tainted identification. That's all that's decided. So then you go to trial, and you've got somebody reading this transcript to the jury. They can't observe the witness. They have no idea what the witness is doing. Is he looking at his feet, wringing his hands, blushing, stammering? They see none of that. They don't have any opportunity to observe him. And this evidence is presented, typed up testimony, and they're supposed to judge from that whether or not the defendant is guilty.
That's every single former testimony exception case.
Well, no, but there's been, I think, Your Honor, I didn't particularly look for cases, I probably should have, that where there was no burden on the state, or the burden wasn't met, and then to the extent that testimony was subsequently admitted against the defendant.
So let's imagine a situation in which Mr. Schenck was quite ill, and the Commonwealth feared he would be dying, and it decided that it wished to have a deposition of Mr. Schenck so that in the event that he were to die, they would have testimony with cross-examination available at trial. Mr. Fontanez decides not to be present for that deposition. Does that mean that the Commonwealth cannot use that deposition at trial against him?
Well, if that deposition, that's a good question. I don't, if they wanted to have a hearing, I guess at that point, if Mr. Fontanez were told that this is going to substitute, the reason we're having this is because this may be necessary to substitute at trial, and he didn't show up, then you'd may have an argument that he waived his right to confront the witnesses against him. Okay. But in this case, there's no such waiver.
Okay, but the judge in the example I gave is not making any finding as to whether or not I believe the witness beyond a reasonable doubt. It's just there is a deposition and nobody's making any finding. So where do you say there has to be some affirmative finding of credibility before that evidence gets admitted?
Well, I think in your example, it's the process that in that process it's designed to substitute at trial for confrontation. I think that's a little different. I think here, that the judge. I think that this possibly highlights the issue that these two proceedings are different. That the process of determining whether or not a pretrial identification is tainted is different from having the person identify the defendant in person at trial. So it may be that that these two issues, and that was part of my argument that the single justice could have determined that these are not the same issues as was decided by the
But
by
that
the
would be a
trial judge.
finding as to the motive for cross-examination, as opposed to anything to do with presence or any need for a finding.
Well, it would be, yeah, the issue, not the, maybe whether the issue was the same.
Well,
not the
that would be
motive.
that would be a completely different case as far as the single justice, because reasonable opportunity and similar motive, minds can differ on that. And if the trial judge had said, well, I don't think this prior proceeding created a, not actual cross-examination, because you don't have to cross-examine, but reasonable opportunity and similar motive, then it seems to me that that's a lot different, because that might well be a discretionary call.
Well, I don't know, Your Honor, that, I don't know why there would be the two, the trial judge and the single justice would necessarily differ on that. It seems like, I mean, if it's just a matter of law, it's black and white. The issue is clear at trial. You don't need, it's not a matter of judging the witnesses. It's just whether you don't need, you can review that de novo with,
But the prior opportunity, reasonable opportunity and similar motive?
yes, whether or not the two proceedings were similar as to, right, the issue and the opportunity for cross-examination.
Well, we've already said in Hurley and in many other circumstances, that's a difficult judgment call that the trial judge makes. For instance, at a 58A, it's not always clear depending on the nature of the 58A.
Well, whether the issue at a pretrial identification hearing, whether the identification is tainted, that issue is clear. And the issue at trial is whether the defendant can identify, the witness can identify the defendant, that issue is clear. And whether or not he had prior opportunity for cross-examination on, and the same motivation, I mean, that's all, seems to me, it's, you don't need to, be present in the courtroom to judge those two issues. It seems that they're,
If your guy, I understand that the victim did not die of the knife wound, but your rule would apply also if he actually died from the assault, right? It would be the same rule, would still be unable to use that testimony, right? So he dies from separate causes, but if, under your rule, if he dies because of the stabbing itself, we still wouldn't be able to use it, right?
right, that would be right. I just,
Think
you know,
forfeiture by wrongdoing might apply there?
No, Your Honor, because I think forfeiture by no, because all the actions took place prior to, I mean, they took place initially. He was stabbed, there was no interaction, there would have been.
I mean, if the defendant kills the witness.
Right, if he comes back and stabs him again, yes,
Yeah.
but I mean, but if he just
Okay,
dies
so in
from the
those
first stabbing.
circumstances, in answer to Justice Kafker, not Chief, sorry, Justice Kafker's question, the answer would be, in those circumstances, forfeiture by wrongdoing might apply and the case could proceed.
No?
No?
Forfeiture by wrongdoing requires intervention by the defendant after the, I think after the case is going to be, involved in legal proceedings to prevent the person from coming to court or testifying against him. But
Killing him
there's-
wouldn't do that?
I'm sorry?
Killing him would
No,
count.
but it all took place prior, that was the initial crime. There was no subsequent interaction to interfere with the witness coming to court. He just,
I'm talking about a second.
oh, I'm sorry,
Yeah.
yes.
Okay, well,
Yes,
forget
yes,
it.
yeah.
It doesn't
Well,
matter.
that might, I don't know, that's, I understand. I
matter.
thought you were, yeah, no, I understand, but, okay. But, in any case, looks like my time's up, and
It is, so thank you, sir.
thank you, Your Honors.